Good afternoon, everyone. I'm Vicky Gilwar from Privacy Culture, and as usual, I'm here today with my business partner, Steve Wright. Hi, Steve.
Hello, good morning. Decidedly excited to be here today. Talking about Brexit.
It's sure to be, we hope, a very exciting episode of Data Matters today. And we've just heard the PM announce that a no-deal Australia-style relationship is looking more likely post-Brexit. I don't think we could get much further away from Europe, really, could we? But let's see. And joining us this week to unpack that is Helen Woollett. Helen is Group Compliance Counsel and DPO at The Body Shop. Welcome, Helen.
Thanks, Vicky. Hi, everybody. Great to be here.
We're also delighted to have Kate Colleary with us. Kate is IAPP Country Leader for Ireland. Hi, Kate. Welcome.
Hi, everybody. Yeah, delighted to be here, beaming in from Dublin.
Thank you so much, both of you, for joining us. So today we're going to be looking at the Brexit data issues that matter to us all, things like international data transfers, legacy agreements, and existing contractual relationships. We've heard a lot about how we should be preparing for Brexit, so we thought it was time to put forward some practical steps and solutions that we can start to put in place now. So we're going to start by setting the scene. The UK left the EU on the 31st of January with a deal called the Withdrawal Agreement. However, its purpose was to set out a process to allow the UK to leave the EU as smoothly as possible, not the terms of the future relationship. And it covered things like agreeing a transition period and how it would work, how to prevent the need for checks along the Irish border, and the UK's financial settlement within the EU. Since then, the government have proposed a withdrawal bill that effectively breaks international law, and yet as privacy professionals, we're all stuck on what to do and when. Negotiations aimed at agreeing the new trading relationship has hit the rocks. Areas like fishing, access, the regulation of medicine and security cooperation were always intended to be held after Brexit Day and during the transition. But with COVID and two stubborn parties perhaps, who will win in the long term, and what are the implications for us as a DPO and a legal community? So let us begin then. The UK is no longer a member of the European Union, but that's not the end of Brexit, is it? Can you explain the chronology and why this all happened in the first place, please, Steve?
I certainly can, but the first thing you have to acknowledge is that Brexit was a very divisive subject and still is. And I'll give you an example, Vic. I had to agree to disagree with my parents, and so we were divided in our family, and that was the story across the country, no doubt. I think I'm going to give you just a little bit of context of why this is so significant, why this is so important, because this all started, if you remember, as out of the war, about an idea of cooperation and collaboration across the member states so that we wouldn't have such things. And NATO was born as a result of that. And then the EEC, as it was back then, was formed in 1957. And guess what? The UK wanted to join and were rejected by our French friends, President de Gaulle, twice, in fact, but we kept coming back and asking to join the party, and finally they let us in 1973. So all things were going smoothly, allegedly, up until, would you believe, 2000, till 2013, when David Cameron decided that if the Tories were to win, he would hold a referendum on this subject. Give it to the people, he thought, put them in charge of such an interesting debate. And of course, 2015 saw the Tories win, and then lo and behold, 2016, 23rd of June, we were asked to vote. Do we want to stay in or do we want to go out? And we all know that it wasn't as binary as that, but hindsight's a wonderful thing. And the other and here we are, right? And as you just painted the picture, we're now in a situation of transition period with the withdrawal bill, which contradicts, international law. and yet we're giving lots of different messages, and it's incredibly difficult for us as data protection professionals to sort of navigate this and tell our organizations and advise our clients on what to do and how to do it. The other thing I just want to paint a picture, you know, we actually trade about £87 billion worth of data with the EU alone in the last year. And in fact, between 2013 and 2020, the data economy in the UK grew twice as much as the rest of the economy. That means that by 2020, you know, pre-COVID probably, it made up 4% of GDP. So data is a massive commodity that we are trading and dealing with. And in fact, it's estimated that in 2018, for example, the total value of data traded globally to the UK was £190 billion. And that 67% of those were UK exports of data. So data is traversing these networks. We also imported, by the way, £90 billion worth of digital services or data services. So you can see that it's a huge part of our economy. And the only other thing I would just want to add, just to set the scene here, is that in the last 8 years, we've seen a 50% increase in jobs which are data professionals. So the whole data professional economy, including privacy professionals, data scientists, data analytics, now make up half of the population. And in fact, of the working population, which arguably is a little bit down at the moment, 48% of the workforce, the UK, so about 30 billion people in the UK, 48% of those people use data every day to do their jobs. So this is a massive part of our economy, a part of everything we do. And here we are facing Brexit.
Fantastic. Wow. That was an avalanche of information, but so helpful and clear, Steve. And yeah, I mean, it's a really great segue actually into the next question, because as you say, the deadline is fast approaching and the changes are going to affect many areas of life, including trade and immigration, as you state. And it won't be long. It's, you know, the 1st of January 2021. So I'm going to turn to our guests now to look at what are some of the key issues for us as privacy professionals, and what should we be starting to think about in preparation for this change. Helen, would you like to start unpacking that for us, please?
Yeah, sure. Thanks, Vicky, and hi, everybody. So what are some of the key issues that you need to consider as a privacy professional? One of them is exactly where is your organisation established? So the reason this is relevant is that you may need to appoint a representative in the EU if you're not established in the Union, but you're processing personal data of EU residents rather. So it's very important for you to work out how your organisation operates in the EU for a start, and also equally how your organisation operates in the UK. It's really important to realise that on the 1st of January, assuming that there is no real deal, there will be a UK GDPR and there will be an EU GDPR. So this is the effect of, take a deep breath, it's the effect of the Data Protection, Privacy and Electronic Communications Amendment, etc. EU Exit Regulations 2019.
Wow.
Which means, or which is given effect to the GDPR into local law, plus the derogations under the UK Data Protection Act 2018. So what those regulations seek to do, it's a statutory instrument, it seeks to give effect to the GDPR in local law. And therefore you've got a mirror image of the GDPR in the UK. Eventually though, those two laws will diverge through the operation of case law and also through the operation of regulatory powers. So going back to the original question that you had, Vicky, What do you need to think about? You need to think about, are you established in the EU? If not, do you need to appoint a representative? You need to work out, if you appoint a representative, what jurisdiction you'll do that in and who will become your lead supervisory authority in case there is an issue in the EU. And finally, the thing that a lot of people have been talking about is, what do you do about your standard contractual clauses and data transfers in the event that there is a cutover on the 1st of January? So I'll leave it at that for the time being, and then we can elaborate on some of these issues later on.
Fantastic, really clearly stated. Thank you so much for that, Helen. Kate, do you have any builds on that, particularly as you're kind of looking at it from perhaps the more of the EU perspective?
Absolutely, and Helen has looked at this very clearly from a UK controller perspective. We, in Pembroke Privacy, I'm a director of a data protection consulting practice. We have been so busy advising on Brexit readiness for UK companies looking, as Helen mentioned, for Article 27 representation, maybe outsourced DPO services, and increasingly data localization. So increasingly moving data offshore from the UK into other jurisdictions in Europe. And Ireland has been one of those favoured jurisdictions due to presumably similar common law jurisdiction, English-speaking country. So to some extent, we've been busy looking at that, and we certainly were in the lead up to COVID. Of course, once COVID hit, I think maybe Brexit was pushed off the headlines a little bit throughout Europe, maybe more so than in the UK. The big issue that we've seen most recently has been around the outcome of the Schrems II case. So we've been helping organisations, particularly in the US and Canada, look at their situations around that, but actually helping them deal with Schrems II can also help organisations deal with a no-deal Brexit outcome as well, because as Helen said, the things we need to think about are those data transfers. Where does the data flow, and what mechanisms are in place to facilitate that transfer of data? So if people were relying, say, on Privacy Shield in the US and now need to migrate to other mechanisms like standard contractual clauses plus, the work that they're doing in assessing those data flows and those data transfers can be really helpful with Brexit as well, because we can build upon that, maybe also ask ourselves the same questions we'll be asking, say, US processors or US controllers to whom we transfer data around security and things like that. And they'll be the same questions we'll be asking around Brexit preparedness. Speaking from Dublin, as I am, obviously there are significant concerns here, and there are wider societal concerns, which I guess that'll just upset Steve and all family members, I think, of all of us. So maybe let's not get into that. But acting as we do for organisations in Ireland, we act for energy companies, we act for healthcare companies, recruiters on an all Ireland basis. So we act for these organisations that treat the island as one jurisdiction, and that is going to change drastically with a no-deal Brexit. So these organisations that have maybe data relating to employees north and south, the south in one database, suddenly are we going to be looking at siloing that database? Are we going to be looking at BCRs? So those sort of issues are live for clients as well, and I think particularly, perhaps uniquely here, because of the joint nature of the relationship between Northern Ireland and Southern Ireland.
Thanks so much for that, Kate. It's great to get the perspective from the EU, and as you say, good to tie it in with Schrems as well, in terms of preparedness, and it will give some comfort to organisations that what they've started to do there may help here. But I think Steve mentioned earlier that the level of data traded between the UK and EU is estimated to be worth 87 billion to the UK economy. So what do you think is the prospect of finding trade terms in the end that do allow data to move freely, given the sticking points we mentioned earlier? Helen, perhaps I can ask you to start unpacking that for us, please.
Yeah, sure. I went back to the government public site, and counted the number of trade deals that are due to become effective from the 1st of January 2021. And there are approximately 24 trade deals that include bloc countries. Plus there are 70 trade deals in train and 3 mutual recognition agreements. The 3 MRAs are actually with Australia, New Zealand and US, which I thought was really interesting. But essentially, up to this point, it wasn't that usual to incorporate adequacy in trade deals until the Japan-UK trade deal came along. And before that, it wasn't so much of an issue. Now we're moving to a world of bilateralism, not multilateralism. And as a result, it remains to be seen the extent to which adequacy is incorporated into those trade deals, and whether, in fact, the UK will, whether in fact organisations will have to start incorporating standard contractual clauses a lot more than they used to as a result of Brexit. I think it's going to take a lot of work to determine, for organisations to determine, that is, what all these trade deals mean for their operations. And also, I think it's worth noting that the Department of Culture, Media and Sport has just put out a consultation on the framework for the National Data Strategy, which closes on the 2nd of December. From that consultation, it's not really clear whether the UK government post-Brexit will have a different policy on data transfers. So it's uncertain the extent to which the government will in fact rely on what it calls data adequacy, which is really adequacy, as I think, as the EU knows it, or whether it will rely on other means to secure or regulate data transfers going forward.
Thank you very much for that, Helen. And just before we move on to the next question, Kate or Steve, did you have any builds on what Helen meant?
Yeah, I'm coming from perhaps a European perspective. There are stated concerns in relation to granting of adequacy to the UK, given the well debated issues around the Snoopers Charter, the most recent concern highlighted by the House of Lords on the 13th of October, recognising that there's a real and distinct problem with the chance of getting adequacy status. I think that those chances in terms of the granting of adequacy status to the UK have lessened somewhat since the CJEU decision, was it last week or the week before last, in relation to Privacy International. And the level of surveillance activity undertaken by the UK government has to be recognised. It has been a much understood and debated barrier to the granting of adequacy, and I think the decision of the CJEU in that case is actually only going to make it more difficult, in terms of that indiscriminate surveillance. Now, of course, there are arguments that the surveillance undertaken isn't necessarily indiscriminate, and that there are remedies available and it's subject to review, etc. I just think that establishing a serious threat to national security to meet the requirements of the Privacy International case are going to be difficult. It's going to be difficult to recognise, to reconcile the UK's position on that with the EU requirements in terms of adequacy. That said, what have we got left? We've got 10 weeks left. So it's not looking necessarily, there's a lot to be done in 10 weeks. But if we have willingness, and honestly, I do believe we have willingness on both sides, I think, as a lawyer working in data protection, in terms of any commercial context, there's always going to be pressure. There's always going to be an element of negotiation towards the end of a deadline. It's just as we count down to that deadline, it does seem to get less and less likely that there will be a deal done. And even regardless of that, it's this state of unknowing that is so difficult for us as privacy professionals to manage within our organisations and to work out a strategic plan when in fact, things are so unclear. And I know as IAPP, country leader for Ireland, there's been a huge amount of discussion and talk and webinars. Brexit was the flavour of the day for years until it got wiped off the headlines somewhat by COVID. But I think it is coming back because it is a real and serious concern for privacy professionals within organisations because it is so unclear. I think the chances probably are slim at this point with 10 weeks to go. So what would we be looking at? As Helen said, we're going to have to look at alternative mechanisms. We're going to have to Brexit-proof our businesses and to facilitate those transfers. And as I mentioned earlier, particularly in an all-Ireland context, an all-island context in the context of Ireland.
Excellent, thank you so much, Kate. Yeah, so many things to look at, so many things to do, as you say, and not that much time left to go. So I guess it's not simply going to be a case of if no deal happens, will it be another Y2K moment? Will everything stop? What happens then? What happens on day one? I think that's what people are probably really concerned about is what do they actually need to do now? What do they need to be ready for? Is there going to be a big bang moment where everything's going to change? Steve, what are your thoughts on that?
Well, I don't think we're going to get a big bang moment. I think it's a very fair kind of thing to ask. For me, the preparations that both Helen and Kate have been mentioning exactly what we've been advising on and helping with. I think it's very similar to the Schrems discussion we had a couple of weeks back, where preparation is key here. Sticking your head in the sand is not going to help. So that's the only thing that I urge our clients to do and to think about is, and the DPOs that we work with, what are you doing about it and what are the provisions that you're going to make. But I don't see us, it's not like we're going to be pulling up a drawbridge of data flows. It's so intrinsic, and this is the whole problem with this messy divorce. Who gets the kids and on what days and all of this kind of good stuff, and that essentially we're going to have to find a way around this because it's in the interests of the kids, if you like, the data. We all want to continue doing business. Trade still needs to happen. So I'm a little bit of an optimist, and I suppose I'm with Kate here, that I feel that by hook or by crook we might get somewhere, but my key message would be around, no, I don't think it's suddenly going to stop, but you should be very prepared for alternatives, and that's, I think that's a fair thing that I can certainly see happening, that you're going to need a preparation, you're going to need a plan. If you're not doing so already, then you need to get onto that pretty quick.
Excellent, thanks Steve. We do have a lot of questions coming in from the audience, so I think I'm just going to ask one more of our considered questions to our panel before we move across and start to look at some of the things that the audience are asking us. And this one is around data subject rights. So given the DPO is responsible for ensuring that data subject rights are upheld and maintained, and the DPO role is to work with different supervisory authorities across the EU, what advice would you give an EMEA DPO on how to manage these relationships across Europe? Kate, perhaps I could ask you to consider how that might work.
Yeah, so for an EU-based organisation, obviously One-Stop Shop will continue to take effect in terms of cross-border transfers. In terms of UK entities, well, I guess we've been here before. We've seen under the 1995 directive, there was an element of having to deal with regulators on a cross-jurisdictional basis and develop those relationships. So I guess it's not as if UK-based entities are starting from scratch. They will have hopefully developed those relationships, and certainly work going to IAPP conferences and things and seeing how the regulators work and listening to them on a cross-border basis can be, or listening to their approach on a cross-border basis can be really, really valuable as well. And back to where we were, I guess, that slightly less harmonised approach, because the one-stop shop won't apply if you're a UK-based business. And other than maybe if a decision is made to relocate a place of main establishment to an EU jurisdiction, and as I said at the outset, we have started to see that. We have seen migration of organisations, places of main establishment, to jurisdictions other than the UK. We've seen moves to Luxembourg, to Germany, to Ireland, to the Netherlands. So I think we'll continue to see that to avail of the one-stop shop. Other than that, we're looking at that fragmented, less harmonised approach for UK-based businesses.
Thanks, Kate. It's a really helpful view. Helen, did you have any thoughts on that before we start to look at the audience questions?
Yeah, sure. I think that what will be really helpful is to understand the definition of established under the GDPR, because if the organisation is actually established, i.e. it has a presence or it's got some kind of connection with multiple member states, then it's really important to take a view on what really is the main establishment, how do you want to interact with data subjects in the member states where you're established in, and particularly to the extent that it's important how you do so in local language, because regulators, it's very important to interact with regulators in the right language and in the right way. And that also applies to data subjects. So it goes back to my original point, which is understand totally what your established presence is, and then you can work from there.
Excellent, thanks so much. Some helpful advice there from our panelists.
Before we, Vic, before we go, I just wanted to pick up on the standard contractual clauses, because that that obviously is a mechanism, and I was Kate, who teaches this stuff on behalf of the IAPP. You mentioned something SCCC plus. And I wanted to know if is that a euphemism, or is there something that we don't know about?
That's probably, I think I'm seeing it being used by lots of people. I don't think I can claim the credit for that one. Okay. But essentially what we mean is in the post-Schrems decision landscape, that we can't just rely on standard contractual clauses simpliciter. We have to take other steps in order to rely on them. And that is going to be the same situation with transfers to the UK from Europe post-Brexit. So what we're essentially looking at are the standard contractual clauses with an overarching processing agreement, and also requirements around security. And the big concern in Schrems 2, as we all know, was the surveillance activity and FISA orders and things from the US. So questions around the numbers of orders that are requested and granted, and of course some of that information will be limited on security, on the security basis anyway, but to be seen to run a questionnaire with all of the data processors or sub-processors with which you're engaged, those questionnaires will be useful in the post-Brexit landscape as well as post-Schrems 2. So those extra measures, so standard contractual clauses plus questions about security, plus things like encryption of data in transit and at rest, those sorts of very practical things that have flowed from the decision of the CJEU. That's what in my head we call SCC plus.
Thank you.
If I could just also comment on that and say that the EU Commission was planning to release updated versions or version of the standard contractual clauses, controller to processor. So I haven't seen them come out yet, but one of the main, I think, difficulties for organisations is the extent to which they want to rely on the old contractual clauses or wait for the new ones, which do consider the Schrems 2 decision.
Yeah, a very really good point there. I forgot to mention that. Yeah, we're still waiting for that to come out, so that would be really helpful to us. So yeah, thanks, Helen. Sorry, Vic. No. I had to ask that. It's just I wanted to learn from Kate, as I always do. So back to you.
Excellent. No, it's really, really good. Thank you both. So, right, I'm going to move across to the questions then. There are quite a lot in the box, and as ever, we're motoring through the time, so we'll do our best. So, the first question, do you think that the personal data of UK citizens from UK controllers sent to EU processors could be or would be snagged in the EU and not returned due to Chapter 5. Surely the lawmakers failed to consider data round-tripping or repatriation. Steve, could I ask you to think about that one as a starting point?
No, yeah, thanks for that one. That's a really tricky one. It's a lovely question, and I wish I'd seen it actually. Let me just look it up, because I think it's the right question to ask, but
well, we can always move on to the next one.
Yeah, I've just got it here, sorry.
Okay, so the next one, and I think we've started to look at this anyway, was, do you think the UK will work with the EU on Schrems 2, e.g. to define adequacy like Switzerland and Israel? Helen or Kate, any thoughts on that?
So one thing, I'll just chip in here first. One thing I meant to say before is that I believe the EU Commission's existing negotiations on adequacy are separate from the Brexit negotiations, which are political negotiations. So the existing negotiation on adequacy will be, you know, I, like the others have said, I think it's going to be very difficult for that to be completed by the 1st of January 2021. But the extent to which it builds in Schrems 2 in any way it's difficult to tell, and that's where I was going to hand over to Kate and find out what she thought about that.
Thanks, Helen.
Yeah, I mean, I would agree in terms of the adequacy points that we raised earlier on. In terms of Schrems 2, I think the situation is only getting more difficult. It's not getting easier. The requirements are becoming more difficult, for good or bad, and there are arguments to say that, are we going down a route that is maybe too prescriptive and too limited, but that's for another day. So obviously from the 1st of January 2021, the UK won't be subject to decisions, the legal ramifications of decisions of the Court of Justice. But of course, again, the more, if the adequacy conversation lasts longer than that date, and there isn't a sort of a nice, neat agreement on adequacy prior to the 1st of January, well then adequacy, the further the UK diverges from EU rules and the law, and certainly it's something I think that Vera Jourova mentioned recently, that indications from the UK Prime Minister Boris Johnson that there may be divergences in the UK Data Protection Act and perhaps from a trade perspective to benefit trade with the US. The more those things happen, the less likely adequacy is to occur. So I think, you know, watch this space.
Great, thank you, Kate. And I think that segues nicely into another question here. With a no-deal Brexit, do you believe that in the long run, the European and the UK data strategy can diverge substantially to a point where they're no longer compatible?
So it's a really interesting question, but before I answer that, I need to bring up Article 71 of the Withdrawal Agreement, because I suddenly realised we hadn't really addressed that, and I think it starts from that perspective. So Article 71(1) states that data processed by the UK before the date of cutover needs to be processed on the basis of the GDPR. If there's an adequacy decision, then that doesn't apply. But if there isn't, then they have to basically keep that processing going, even though there may be no agreement. So what you might end up having is, confusingly, very confusingly, two buckets of data, one based on the EU GDPR rules and the other based on the UK GDPR rules. So I think it's inevitable that there will be divergence in the rules between the UK and the EU, even though the foundation is the same. The sticking point for companies is really, is it in their interest to start processing data, different buckets on different bases? because it seems to me that would end up being very difficult to be, to maintain accountability for. And also, you wouldn't want it to be a race to the bottom. I think most organisations want to aspire and achieve a higher standard, not a lower standard. So I know I didn't completely answer the question, but that was the sort of backdrop I had for it. If Kate or Steve want to step in.
Yeah, I would just like to remind us all that, we don't need to be the same. And an adequacy status is never predicated on a cut and paste version of the European data protection rules, whatever they are at the time under the directive or the regulation. What's required is essential equivalence. And in fairness, the UK is starting at a very strong point in terms of its Data Protection Act 2018, so based on European norms. So probably, aside from the concerns that we have in terms of the surveillance activity and the snoopers charter, etc., from an equivalence perspective, I think the UK is starting from a good position because we have the very, very similar frameworks integrated into the Data Protection Act 2018 in the UK. So unless there was going to be a huge change in that legislation, which is probably unlikely given that there's likely to be lots of turmoil about other things going on, I would say that that is a good starting place for future relationships.
Great, thank you, Kate and Helen there. And again, a related question as we're talking about adequacy. Would you advise UK entities to process EU residence data, delegating the process into a country with proper EU adequacy, for example, Japan, Switzerland, or even Argentina, instead of processing it in the UK, which is unlikely to receive full EU adequacy?
Wow, that's a tough one. I think it's very hard to tell at this stage what the best strategy is on that, simply because we don't know enough. I mean, without wanting to provide any advice, of course, without knowing the real circumstances. I think if you start adequacy shopping, that's what we're talking about. Probably there are other more important business issues to consider apart from that. Kate, I don't know what you think.
If we were going to look at, I love that concept of sort of forum shopping, adequacy shopping. If we're going to look at adequacy shopping, why would the UK entity, so this is going to open a whole can of worms, would the processing not be undertaken within the EU? If we're going to be forum shopping, if you can do an element of the processing there. But I suppose, as I said, that may end up opening other issues in terms of those data transfers.
Would it be just to avoid doing a whole lot of SCCs in the short run, perhaps? I don't know.
Yeah. So interestingly, binding corporate rules tend to be the Irish regulator as the lead regulator for many multinationals in the post-Brexit landscape, or the lead up to the 1st of January. The Irish DPC has seen a huge increase in the number of BCR applications as well as an alternative transfer mechanism.
Thanks, Kate. Just a couple of comments that have come in from our audience here. Apparently SCC Plus came out of the Japan to EU adequacy discussion related to onward transfers.
There you go. Thank you.
And another comment that says adequacy is technically non-political, but as a derivative of the recent Luxembourg court judgment, it is related to Visa 701 and other Five Eyes surveillance issues. Steve, whilst we've been going through those, did you manage to find the answer to the earlier question?
Thank you for that question. I think, was it Nigel or Nigel or George? It really was a good question. It got me searching through my text to find out. I think I can't answer it directly, so I can take it offline. But what I think, having read the text, what he's saying now there is, did they fail to consider repatriation? And I think, I don't want to prejudge. The problem with any law is that it suffers from huge amounts of collaboration and, if you want, sort of self-protectionism, should I say. And, you know, I remember when the repatriation laws of Russia and China came into force, and we suddenly had to take our data sets and duplicate them, even though we were in the cloud. And, you know, it got really, really silly. And you know, so the whole repatriation challenge, I think, is obviously here to stay. But whether or not they sort of considered it, well, Nigel, your guess is as good as mine. But I would imagine that maybe they did, but it got lost in the text of trying to get 28 member states all signed up to a piece of law, which is an incredibly hard process. And we all know it took an awful long time. I do recall, I don't know if Helen and Kate recall, but I remember seeing leaked text of GDPR probably, I'm going to say 9-10 years ago. Is that about right? It feels about right. So it was a long process. It was one of the quickest. It took 4.5 years to draft, and it was one of the quickest to get through Europe. But still, there's a lot of people with a lot of, if you like, self-preservation caveats being added and negotiated. So incredibly difficult.
Yeah,
Nigel, but I'm happy to take that question offline, Nigel.
Thanks, Steve. So we've got 2 last questions before we wrap up and ask our panelists for their nugget of advice to leave you all with. This one: I'm a DPO for a European association registered in Brussels but hosted in the UK. Should I move the hosting to the EU before January 2021? Thoughts on that, Steve?
Well, Professor, I think you know the answer to that one, but it's not for us to say. And I think the important thing about that is it depends. It depends on what you're doing and the mechanisms that you and the contracts and ultimately the purpose of what you're doing with the data. So it's a tricky one to to give you a straight yay or nay. I think the guests here today have put some excellent sort of pragmatic advice on what to do and the steps to take. And I think with all of these things, what I love about the text, GDPR text, is it does mention risk and proportionate, and I think there is an element here of understanding your business's risk from moving potentially from Brussels or from the UK to Brussels. But thanks for the question, Professor.
Great, thanks, Steve. Okay, just one final question for our panelists then. Do you think that UK membership of Five Eyes Alliance will be an obstacle for an adequacy decision? Helen or Kate, any thoughts on that one?
So that's the age-old Ripper question, isn't it? So I think really it's about the extent to which the EU regards the Investigatory Powers Act as being problematic for adequacy. The Five Eyes Alliance refers to sharing of data that would be obtained under RIPA, I think. But there's been a lot of speculation about this. I don't know whether we know the answer in reality, because as Kate has said, there's been a CJEU decision on this, and some of these negotiations are still being undertaken. So I'm not sure whether we really know the full position on this.
Thanks, Helen. Kate, did you have anything to add before we start to wrap up?
Not necessarily, other than to say, I guess, in terms of considering those issues, I know Vera Jourova during the week said that she couldn't predict the outcome based on Boris Johnson's previous indications and suggestions that the UK may seek to diverge from the GDPR. pursue maybe a more liberal data protection approach. But I think, again, it's a wait and see. And as Helen said, it depends on the extent to which the Snoopers Charter or the UK Investigatory Powers Act is going to be a problem for the European Union.
Great, thanks so much, Kate. And while you're there as well, are there any final thoughts that you'd like to leave our audience with in terms of the best next steps before?
Yeah. I mean, I think we're learning a lot through Schrems 2, through the previous work that most organisations have done in Brexit preparedness. So take some heart in that. Take some heart in the fact that, the first step is to assess what we have. And a lot of that is going to be contained in our Article 30 record of processing activity, which many organisations will have got into place pre-GDPR. So based on that, have a look at the transfer matrix, have a look at the data flows, and then assess those transfers. And we've been very busy doing great Excel spreadsheets based on transfers and attributing risk to each of those transfers. So transfers in and out of the UK, risk based on, I suppose I'm always looking at it from a more European perspective, because we're looking at into the UK as opposed to out, and Helen can hopefully help us on the ex-EEA transfer, ex-UK transfers. But attributing risk based on the data location, based on the type of risk, based on the type of data, based on the special category personal data, etc. And then based on that, talking to data processors and seeing what mechanisms are they going to put in place to facilitate those transfers, or indeed other data controllers. And then the ultimate, then as Steve said, this is a risk-based approach. GDPR does not prescribe many things. A lot of it is about organizations assessing their own risk and making decisions in the knowledge of that risk. So this is a risk-based approach as well. And based on that approach, can we take the risk and use standard contractual clauses to facilitate transfers, or some other mechanism in the event of a no-deal Brexit? Or, the ultimate is data localization. And that's, I don't think, maybe where any of us really want to end up, where we start siloing data in different jurisdictions. I think that's going backwards rather than forwards. So do an assessment. Luckily, I think we're in a good place if we've done our GDPR homework. Again, with Schrems 2 reminding us of that. Leverage that, use that good work to assess where those data flows are, assess risk based on location and type of data, and then deal with each of those controllers or processors or transferees and try and work out what's the best mechanism.
Thank you, Kate. Really sound advice there. Helen, your final thoughts?
Thanks, Kate. I don't think I can really top that advice. So that was really great. I think the checklist approach is essential in this kind of an exercise. Also, establishing the facts. I mean, sometimes in very large organizations, it's very hard to tell exactly where data is and the flows at any one point in time. Just going back to this whole issue of repatriation, and originally it looked some of the law looked a bit like a reconstruction of batch processing, as we used to know it. And these days it's very difficult to describe data flows at a point in time in complex organizations. But if that can be described in a simple way in terms of establishment and main establishment, I think then that can help decision making hugely. And also, one thing I don't think we touched on really is the extent to which DPOs are required in member states or in jurisdictions if you're processing large quantities of sensitive data, or you're required to have a DPO. And I think that might be hugely helpful, because you might be able to get a DPO to interact directly with the relevant regulators, and then there's less of an issue with the regulators if something happens, where you need to actually interact with them on an urgent basis for some reason or other. So that's where I'd leave it. Thank you very much.
Thank you so much, Helen. Excellent builds. And finally, some final closing thoughts from you, Steve?
Yeah, well, as usual, every week there's always stuff. I scribble notes, and there's always something we learn and I learn, and it's brilliant. And that's one of the reasons why we love doing these shows. So really, thank you, Kate. Thank you, Helen. Fantastic answers. I just wanted to remind everybody that actually next week we've got another couple of great guests, and we're tackling the similar sort of subject, but of outsourcing and cloud. And so we're going to be diving into that and looking at sort of some of the constraints and the challenges. And we've got a professor joining us for that, and another guest. So I'm looking forward to hearing next week's challenge and how we tackle that. But I thought you're absolutely right, Kate. Spot on. Really, really useful, pragmatic, and stuff that we can definitely take away from this. And Helen, as always, your thoughts on this are just really brilliant. So I thank you again. Back to you, Vic. Looking forward to. I'm actually looking forward to a cup of tea. That's what I'm looking forward to before my next meeting.
Definitely, and thank you so much for listening. Thanks so much to our guests for giving up their time and, as Steve said, giving such great pragmatic advice to our audience today. So I'd just like to say thank you again and goodbye to Helen.
Bye everybody, thank you.
And also a big thank you to Kate. Thank you so much for your advice, and see you soon.
You're more than welcome. Thank you all.
And thank you so much to our audience, and we'll see you at the same time next week. Have a great weekend.